The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome, counsel, and welcome to all of those who are watching on our Supreme Court Live channel. I would now ask Mr. Doug Shima, the clerk of the Kansas Appellate Courts, to please call this morning's 11 a.m. docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Thursday, October 28th, 2021 consists of one case. Appeal number 122961, State of Kansas versus Michael J. Pearce, Miami County. Briefs both sides. Your Honor, the appellant has reserved 2 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
The appellant, Michael Pearce, appears through counsel Michelle Davis. I'm present and ready for argument.
And may it please the court, Assistant Miami County Attorney Jason Vigil, appearing on behalf of the state of Kansas appellee, present and ready for argument.
Thank you, counsel. Ms. Davis, you may begin your argument.
A brief factual summary. A woman by the name of Nicole Razzo was looking to buy a controlled substance, methamphetamine. She shows up, drives out to country road, rural area at night with three gentlemen in her car. It's Nicole Razzo seeking to buy drugs with two men who served as intermediaries. And then there's a fourth man in the car who served as a witness. Meeting them out in the country were the sellers of the drugs, and that's the car driven by April Lunsford. Her intermediary, a man by the name of Rhodes, gets out of the car and takes the drugs over to Nicole Razzo and comes back with money. Lunsford had expected $200. Instead, they only got $100. At this point, the two other people in the seller of Lunsford's car, those two other people are Heather Briggs, who is the deceased in this case, and Mr. Pearce, the defendant. Get out of the car. Heather Briggs went because she knows Razzo and she wanted to take care of it. Apparently, she and Razzo has some history together. And at some point, Mr. Pearce also goes to Razzo's car. This altercation, fighting words, takes place where Briggs is banging on the hood of Razzo's car saying, "B word, get out and fight me." And Razzo is apparently makes some sort of threat, or it says, "I'm going to run you over." At some point, Razzo, I guess, complained she's also been shorted on product. At some point, there was some talk of just, "I'll give you the drugs back and you give me the money back." Briggs starts to head back towards Lunsford's car. Apparently, there's some testimony that Mr. Pearce makes a threat to shoot the car up for different reasons. There's a few different quotes in the briefs. Briggs is in front of the car. Lunsford gasses the car, takes off towards Briggs. Briggs stumbles into a ditch, apparently, and Razzo runs her over. And as a result, every participant in this got charged. Mr. Pearce and a gentleman in the seller's car went to trial. The others took pleas to involuntary manslaughter, reckless, including Razzo, who actually ran Briggs over. One of the gentlemen in the seller's car was found not guilty, and he testified on behalf of Mr. Pearce. Mr. Pearce was convicted of felony murder in the distribution of drugs, criminal threat, and the distribution of drugs. And really, there's the main issue that we raise on appeal here is that whether this conduct, this killing by Razzo, whether Mr. Pearce is responsible for that, whether that falls within the purview of felony murder. And the tangential issue with that is the causation element between the underlying felony and the death of Briggs. So basically, felony murder is a killing in the commission of the underlying felony, as this court's well aware. The jury is instructed to determine whether the killing was committed while that Briggs was killed by defendant or another while the distribution of drugs was being committed. This court several years ago in a case called HOANG for the first time said that felony murder covers more than just the death of innocents. And in that case, it was an arson, and the defendant and some of his accomplices committed arson, and one of the accomplices was killed. And they said that the co-felon can be held responsible for the death of another co-felon. And then in two later cases, this court limited the application of felony murder and said, for example, that a law enforcement officer or a victim acting in self-defense, that's not within the scope of the felony. And so therefore, any killing that takes place by those actors, they cannot be convicted of felony murder. And so it's our contention here that Mr. Pearce, neither Mr. Pearce nor any of his co-felons, which were the sellers, the distributors of the drugs, caused the death of Briggs. It was Nicole Razzo, who was not a co-felon in the distribution of drugs. She was simply seeking to obtain drugs. That her actions were the direct result and the cause of Briggs's death. So
let me just interrupt you, Ms. Davis. What it appears from the briefs that you disagree with your opposing counsel on what the standard of review is for this. What do you believe the standard of review when we're looking at this causation issue?
I don't think we disagree. I just think there's several standards of review that apply because causation is an element of felony murder. And so there's case law that it's basically a question of law as to the scope of felony murder for this court to decide and how far the causation and the reach of felony murder apply. And that's a matter of law. I don't disagree with counsel's assertion that the evidence has to be viewed in the light most favorable to the state. But really, I'm not really challenging the evidence per se. I'm more challenging how this court interprets the statute and applies the causation and whether Mr. Pearce is responsible under the statute, given the facts of this case.
Thank you.
Okay. So I guess the question becomes, the state, if you look at the state's argument in this case, they seem to claim that Razzo is a victim here. They claim that Mr. Pearce makes this threat, and that's what causes Razzo to take off scared and run Briggs over. But the state did not charge that this was a killing in the commission of criminal threat. The state charged that this was a killing in the distribution of drugs. And again, if you say this goes to the distribution of drugs, well, then Nicole Razzo is not a co-felon because she was not distributing drugs. She was trying to buy drugs. And there's a difference. There's a difference between a drug dealer and someone who's trying to buy drugs. So
Ms. Davis?
Yes.
Sorry, I didn't mean to interrupt you. So is your argument really that our felony murder statute should be interpreted under sort of that agency theory that was discussed in sophomore? Meaning if you understand what I mean by that, go ahead and answer. But my understanding is that if the person that caused the murder is outside the agency relationship of the defendant, then felony murder wouldn't apply. Or that's the rationale I think that I see in sophomore.
Yeah, and I don't think that case specifically told us whether it was adopting the agency theory or the other theory. I think I'm just going off of this court's case law where this court has limited application to a co-felon. And I'm not sure, I don't know enough about the agency theory, but I think that's somewhat comparable to the agency theory, but they didn't say they were doing that. I think
my question though is after sophomore and Murphy, we have cases like Belts and Jackson, where the court was not willing to apply the holding in sophomore to this type of drug transaction, given its inherently dangerous circumstances surrounding those types of transactions. I mean, I guess my question is, how do those subsequent decisions, don't don't they resolve your or eliminate your reliance on sophomore or Murphy? Or how do you distinguish cases like Belts?
You know, the case that I looked at, and the case I cited in my brief, is Bryant, and that's from 2003. And I think what you normally see in these cases is there's an attempted robbery. And so you've got a buyer seller, but really what's going on is one of them tries to rob the other, and the state charges the underlying felony as aggravated robbery. And that's what usually takes place. That's what's different about this case. I was looking at the Bryant case, and that's a case where the defendant's the buyer and his accomplice, and they go in, and his accomplice is shot by the drug seller in self-defense. And the court said that he's subject to felony murder, but the underlying felony was robbery. So his co-felon, he was a buyer, and the co-felon was shot in the robbery. So I think that's what's kind of different here, is that you don't have
Right.
that.
Right.
So
But in cases like Belts, the underlying felony is the distribution, the drug transaction.
and I'd have to go back and look. I don't know if this argument was specifically made in that case, and if the defendant was, or one of his accomplices was actually distributing the drugs. I'd have to go back and look and see if they actually made this claim. I'm not sure that this claim has directly been made to this court to try to distinguish between the buyer and the seller. And again, I don't think this court has had to, because it's usually been a robbery situation. But I'm sorry, I'd have to go back and take a look at that case specifically. So the jury in this case really doesn't decide this issue, because the jury isn't instructed on the causation requirements and this whole idea of an intervening cause and what the scope of felony murder is. And that's just not a standard instruction. It wasn't requested in this case. It's not a standard instruction. So the jury is just simply, all that's required is they determine if this killing was done while the felony was committed. So I think that's why this court legally has to determine the scope. That concludes my comments. I think I've covered what I need to, unless this court has any more questions.
I do have a question.
Okay.
So you're framing this as an issue of law because, like you said, the jury instruction just said, the statutory requirement while the felony was being committed.
Mm-hmm.
Why isn't, when we look at it, is that not a sufficiency of the evidence issue when we're looking to see whether or not, it happened during the course of the drug or distribution of methamphetamine? I mean, the defendant in this, do you agree that he did engage in distribution of methamphetamine?
That's right. Yes. I mean, I'm not necessarily agreeing with that, but the jury did find that, and there is evidence to support that. So we're not challenging that. I think what we're challenging is, given the facts of this case, that none of his co-felons in the distribution of meth caused this death. This death was, I'm trying to draw the analogy between a shooting by a law enforcement officer or a victim defending themselves. And the victims caused the death, not anyone participating in the felony. And so, I guess it would be saying, I'm going to give you an outrageous example, but if they were standing out there and lightning came down and killed Heather Briggs, she was killed in the commission of the felony. But is Mr. Pearce responsible for that? And I know the statute says the defendant or another killed, but in the same way that if a law enforcement officer had killed Heather Briggs or a victim does the killing, then Mr. Pearce isn't responsible under the statute, because it has to be someone committing that felony. And he didn't do it, and none of his co-felons did.
Rather than view this through the sort of strict lens of who did the killing, is it appropriate to utilize sort of tort law principles of foreseeability? Because I could see at least an argument that the lightning strike is not foreseeable. Whereas getting shot by a police officer might be foreseeable if you're engaged in a dangerous felony.
I think that takes it a step more, because causation is more about who has a direct cause of death.
Well,
whole
foreseeability has always been an element of common law causation. So why can't we utilize that principle in the felony murder context? Because at least it would exclude your hypothetical of the lightning strike, at least arguably.
Yeah, I just don't know that the law supports that. I'm looking at my legal definitions here of causation, and I just don't see that in there. The definitions I have of causation are talk about unbroken by any intervening cause. The legal cause is the injury would not have occurred without it. It's your actions produce the injury. It's a natural and probable consequence. You're the direct cause of the death. That sort of language. I just haven't seen foreseeability as, I know that's an aiding and abetting theory. But for example, I mean, the example of that would be you're going to distribute drugs and one of your co-defendants tries to rob somebody and trying to argue that you weren't there to rob anybody. And the state argues, what was foreseeable, somebody would try to rob and you're liable. I see that more in that situation.
We did in Nesbitt in 2018 say to determine if an intervening event, which is what, whether it's a lightning strike or whether it's in the middle of a criminal violence during a drug sale, Nesbitt does say we consider foreseeability.
Okay.
So, and in that particular case, we held that criminal violence during a drug sale is not an extraordinary intervening event, which is one of the definitions of causation.
Again, though, it's just the foreseeability and the causation is to say, again, how far you want to expand the scope of felony murder. And you want to say, I mean, it's foreseeable also that a law enforcement officer may arrive on the scene and shoot your co-felon. It's foreseeable that a victim may shoot a co-felon. But how far do you want to go with that to say that I as a defendant am responsible for that I'm responsible for the death when the victim shoots my co-felon? So that all may be foreseeable, but I'm not sure that the legislation writing the felony murder statute intended for the responsibility to attach.
But in this case, do we have a victim or a law enforcement officer? You're asking us to push it to basically a co-felon, right?
Well, I don't think she was a co-felon. The person who did the shooting here was not a co-felon in the distribution of drugs. She may have been a victim. I mean, she was a victim because apparently Mr. Pearce threatened her, and then the state tries to claim that she drove responding to that threat. So maybe she's a victim. She's a felon, but she's a felon in a different act. She's a felon in attempting to possess methamphetamine. That's where she's a felon, but she's not a felon in the distribution of drugs.
But is she an innocent third party?
That's the interesting question. She is a third party. I'm not sure we call her innocent.
I'm not sure.
But she is a third party. She's a third party to this. I wouldn't be making this argument if one of Mr. Pearce's accomplices had run Heather Briggs over.
Thanks.
Okay, thank you.
Any other questions? Thank you, Ms. Davis. Mr. Vigil?
May it please the court. As this court has recognized time and time again, and as pointed out by Justice Standards just now, criminal violence that erupts during a drug sale is not an extraordinary intervening event. And such violence, when deadly, can also precede a defendant's criminal participation in the drug sale and will not cut off his or her liability for felony murder. Your Honor, a quick summary of the facts is defendant participated in a drug deal where both sides attempted to cheat the other. Both sides realized this, predictably so, violence resulted, specifically because of the threats defendant made related to this ongoing drug deal. I'm going to go ahead and address these two sub-issues related to felony murder in the order defense counsel raised them. First, regarding whether or not Ms. Razzo must be considered an actual co-felon to the distribution itself. That is something that's simply not in the statute, and defendant attempts to actually read something that just is not there. And case law is clear, it's whether or not someone's a co-felon to an underlying inherently dangerous felony is dependent on one's participation in that underlying felony. Those two cases that defendant relies on, Sophofone and Murphy, are both inapplicable here. One involves a co-felon running from authorities and engaging in gunfire with police, and that co-felon subsequently being killed by police while the defendant was in back of a patrol vehicle. Murphy involved a situation where a victim to the underlying inherently dangerous felony killed a co-felon out of lawful self-defense. Together, both Sophofone and Murphy offer the narrow holding that felony murder is not applicable when the death of a participant in the predicate crime results from lawful actions of law enforcement or the resisting victim engaging in lawful self-defense.
Counsel, can I ask you, I agree with that statement, but I guess my question is, why is that the case? Is that the rule because we have adopted this agency theory of liability, or is it some other reason, like in those situations, there's actually no murder because it was a justifiable use of force, and therefore we don't extend criminal liability in those situations? I guess my question is, what is the rationale underlying the holdings in Sophomore and Murphy?
Yes, Your Honor, my reading on both of those cases is not only the justifiable legal use of force, but also the fact that in those cases, it involved an unwilling and unrelated individual, a third party essentially, to the underlying felony. And then in this case, you have a willing and active participant, that being Nicole Razzo, actually committing the offense. And that's the main distinguishing factor here in this case, and why those two cases are not applicable here. So here right now what we have, the death of Heather Briggs, it's far from those considered in either of those two cases.
I appreciate you utilize your prosecutorial discretion here in charging Mr. Pearce, but could you have charged all the participants in this transaction with felony murder?
They were, Your Honor.
And then you reduce the charges. All of them were initially charged with felony murder, and then for cooperation, the charges were reduced.
That is my understanding. Yes, Your Honor.
Okay, thank you.
So right now, the cause and fact chain between the actual underlying inherently dangerous felony, that being the distribution of meth, and Heather Briggs's death, that goes to the sufficiency of the evidence that defendants trying to claim the causation is insufficient. So going back to, I guess, his first sub-argument that's raised in the brief, whether or not Nicole Razzo acted as an independent party, being an extraordinary intervening event, that's just not supported by the evidence and what was examined at trial. Defendants active and direct participation in this drug deal is what caused Heather Briggs's death, according to how the evidence unfolded at trial. First, we have two witnesses presented by the state. That was first Seth Herron and Nicole Razzo, who both testified that defendant was the one that confronted Nicole Razzo about the money that was shorted for this drug deal. Seth Herron first testified that defendant pulled a gun outside of Razzo's car, waved it around, and threatened, if the money doesn't show, I'm going to shoot you guys. And it was because of this threat, according to Herron, that Razzo drove the vehicle out of fear, fleeing from defendant and running over Heather Briggs in the process. Nicole Razzo gave a similar account, stating that defendant actively attempted to resolve the deal by telling Razzo, I'll give you the money back, just give me my drugs back. Defendant directed Briggs to weigh the drugs and then turned to Razzo and told her, don't mess with me. If my dope is short, I will shoot you. So when asked at trial whether or not Nicole Razzo thought that defendant actually had a gun on him, she said that defendant went under his shirt, but that she did not want to stick around to find out. Razzo then ducked her head and told the rest of the occupants in the vehicle to do the same as she fled away from the defendant. It wasn't until the other occupants of the vehicle told her that she had hit somebody that she realized that she had inadvertently run over Heather Briggs in the process. Razzo specifically testified that she did not intentionally run over Heather Briggs, but was fleeing from defendant and would not have driven the way she did were it not for defendant's direct threats related to the drug deal. Then there's a third witness, Chris Cooley, further supported that defendant's threats related to the drug deal were made. Cooley was unfamiliar with the defendant, but gave an account that he saw Heather Briggs outside the vehicle with an unknown male individual. This unknown male told Razzo, "Don't do anything stupid or I'll shoot up the car." After this threat was made, Razzo drove her vehicle over Briggs, and Cooley was so frightened by this threat that he actually fled the scene. We have the fourth witness presented by the state as well, David Rhodes, who was actually in the other vehicle with defendant, that being April Lunsford's vehicle. He testified that as defendant exited the vehicle, Lunsford's vehicle, to confront Razzo, he said, "I got this." David Rhodes further acknowledged during trial that he had previously testified that defendant motioned as if having a weapon as he exited the vehicle and made the statement. Then the defense counsel's own witness, Kevin Stevens, was called to rebut the state's witnesses' accounts. Stevens attempted to testify that he did not recall defendant even being there. He didn't recall anything being said about having a gun or seeing a gun, never heard any threats, and that he believed Nicole Razzo intentionally drove the vehicle into Heather Briggs. However, on cross-examination, the state specifically cross-examined Stevens about his very own felony murder trial in this case, where Stevens testified that he did in fact hear someone say something about shooting up the car just moments before Heather Briggs was killed. That transcript was entered into evidence for the jury to consider along with the rest. Specific to all this evidence and the hypothetical the defense counsel gave regarding the lightning strike, those are two entirely separate things. Lightning strike, that's entirely unforeseeable, unrelated to the drug deal, whereas you have the defendant actively engaging in a drug sale and participating in it and making threats specifically related to the drug deal that subsequently caused the death of Heather Briggs. It cannot be said that Razzo's act alone was the sole cause of death of Heather Briggs, because it was defendant's direct participation in the drug deal that set off the chain of events that killed Heather Briggs in the process. This court should uphold the lower court's conviction of felony murder for Mr. Pearce and find that there is no extraordinary intervening event. I'm just going to shortly touch on defense counsel's second main argument in this case, whether or not Section 5 of the Kansas Constitution requires a jury finding of criminal history in order to determine a presumptive sentence under Kansas's sentencing guidelines. I would just refer the court to my brief arguments on that, as well as this court's previous holding in Albano earlier this year that specifically rejected defendants' common law arguments on that issue. See that I still have time, and I'd love to take any questions if anyone has any.
I don't see any. Thank you for your argument. Ms. Davis, you reserve 2 minutes.
To answer Justice Rosen's question, I think the underlying plea that was part of the plea deal was involuntary manslaughter, reckless killing. So basically the state believed that the evidence supported at least that Razzo recklessly killed Briggs. So again, the question in this case comes down to that act by Razzo. Should Mr. Pearce be responsible for that or not? And it's our contention that he should not, because Briggs was killed by Razzo was a third party in this case. She wasn't killed by anyone who was distributing meth. And that's what the state charged in this case. And that's what the state was required to prove. If the state had some other theory that that Briggs was killed as a result of Mr. Pearce making the threat, the state didn't charge that. So again, it's a stretch to say that when he's distributing drugs, that causes Razzo, and he's responsible under the law for Razzo then driving Briggs over. That's the stretch in this case. That's not what felony murder was intended to cover. And this court's never held that. This court's never held that a third party like that is responsible. That concludes my comments. I'm sorry.
That's fine. If Razzo was charged with involuntary manslaughter, that's not a lawful act, right? That's not like self-defense, or that you would agree that that's not a lawful act.
Reckless killing, recklessly killed a human being. That's right. That's what the state allowed her to plea down to as part of the plea negotiations.
She pled down to, but she was
right.
charged with
she was originally charged with felony murder, and the state allowed her to plea. That's why I wanted to clarify for Justice Rosen. That was what it was pled down to, and a lot of the evidence cited by the state was the other people that were with Razzo. And so Razzo, a lot of the testimony that the prosecutor tells you about is Razzo showing up and saying, no, I didn't drive off recklessly or intentionally trying to run anybody over. It was this guy. It was Mr. Pearce, and he threatened me and I was scared. And that's why she got run over. So there's a lot of incentive here to point the finger at Mr. Pearce. And it was two other gentlemen in the car with Razzo that provided this testimony too. They also pled down to involuntary manslaughter, I guess under a theory of aiding and abetting a reckless killing. And as part of the plea deal, they testified for the state.
One other question, I noticed that you didn't touch on the issue that opposing counsel did on whether Section 5 requires jury finding. Would you agree that our recent case in Albano resolved that issue?
Yes.
Thank you.
Thank you.
Counsel, just to clarify something in my own mind, are you trying to separate out the res gestae of the sale of drugs from the res gestae of the purchase of the drugs?
No. I don't think so. I think, the res gestae is the time and the place. So that's not really primarily my argument. I think my argument just goes to that the killing here wasn't committed by anyone who was, I'm sorry, let me rephrase that. I think I'm just trying to distinguish what the state charged and if they proved what they charged. And this court has held that a co-felon is responsible for the death caused by a co-felon during a felony murder. And all I'm trying to say is that Razzo was not, as a third party, she was not a co-felon in the distribution. So she can't be held, the state can't convict Mr. Pearce under that theory. I hope I've answered your question.
Yes, you have. Thank you.
So it doesn't really go to time and place. It more just goes to the charge by the state and whether the state's proven that charge.
But actually, she was a co-felon, right? I mean, you're saying that she wasn't a co-felon on the charge that Mr. Pearce was convicted of, which was the distribution, but she also was charged as a co-felon. I mean, she was charged as a co-felon, right?
A different crime. Not felony murder. I'm sorry, she was charged with felony murder, but you're right. She was charged, she was a criminal. She's in prison. She was convicted of a crime, right? That's true. But again, the state allowed her to plead down to that. I think the state allowed her to plead down to involuntary manslaughter and distribution of meth. I would argue if I was her.
Why does that make a difference?
Well, because if I was her attorney, I would say there's no evidence here to support distribution of meth. But as long as nobody appeals it, that she wasn't, the people in the buyer's car weren't distributing meth, they were buying meth. So when they pled to that, somebody gave a factual basis and a judge accepted it. But if it's a plea, nobody can appeal it. So the state's going to say, well, she was convicted of distribution of meth, but that was pursuant to a plea agreement to avoid felony murder. So there wasn't a jury trial finding. It was simply a plea deal. So yeah, she's a criminal.
She ultimately pled to involuntary manslaughter.
Yes.
Which doesn't require an underlying felony, right?
Right. But she also pled to distribution. My understanding is she pled to distribution. So the state reduced the felony murder charge for a plea to reckless killing and distributing meth. And again, I don't think there's a factual basis to support that she was distributing meth.
Any other
So-
questions? Oh,
I'm sorry, Justice.
go ahead and finish your answer.
So we would ask you, Mr. Pearce was convicted of distributing drugs, criminal threat, and then the felony murder. This issue only goes to felony murder, so we would ask you to reverse that conviction. Thank you.
Anything else? Okay, thank you to both counsel for your arguments this morning. We will take this appeal